Hi, this is Gene Trowbridge, Trowbridge Law Group. Welcome to our YouTube channel. Today we're going to be talking, the topic is the 2022 Securities Primer. In a relatively short period of time, I'm going to give you a lot of information, and then you're going to go through the other videos that are on this YouTube channel. Be sure to subscribe, and there'll be details and more important definitive information for you. And at the end of this video, I'm going to give you an opportunity to get a free PDF of my book, which explains this, the fourth edition of my book called It's a Whole New Business. So let's get right ahead and go with the 2022 Securities Primer. The first thing I think we have to say is, why would anyone do what Gene's going to talk about? Well, if you want to buy real estate or you want to do any business, I mean, we've done racehorses, we've done cannabis, we've done all sorts of things. But if you want to do any of that and you don't have enough money to do it yourself, you're going to have to raise money from other people. You're going to go to the bank and raise money, and then you're going to put your own money in it, and you're going to be short. So what are you going to do? You're going to go out, you're going to do a syndication, which is two or more people pooling their money to do some business venture. And if it's done in a certain way, you do move into the securities world. And that's why my book is called It's a Whole New Business. So why am I talking to you about this? I've been in this business for ages. I was, as you can tell from the screen, I was a syndicator for a long time. At 45, I went to law school. I've represented over 600 unique, and they're all unique, believe me, sponsors, and they've raised over $6 billion in offerings. For those of you who know about the CCIM, I was a senior CCIM instructor for 40 years. I've retired from that now, and went to law school at 45. When I decided not to be a syndicator anymore, I decided to go to law school so I could stay in this business and do it from another bent. So I've been doing this a very, very long time. First of all, I want to tell you about the scope of the private placement business. Private placement means we don't go to Wall Street, we don't go to the New York Stock Exchange, but we follow the securities law in such a way that through what's called an exempt offering, exempt from the SEC, we raise money. And look at how much money is raised. This is a 12-month report from the SEC, the most recent report there was. And in that 12-month period of time, there's over $2 trillion raised in private placements. Now, more than 2/3 of those private placements have less than 10 investors, with the average being about 14. So it's not like you're going to raise money from 100 or 200 people. You can. Some of my clients can, but they've been around for a while. And important, you'll see this come up, 1.9 of the $2 trillion was raised in something called a 506B offering, and $217 billion was raised in 506C. You'll see those numbers, 506B, 506C, and 99% of all exempt capital, which is the $2 trillion, is raised under Rule 506, either in the B or the C category. So here's how many people start with investing in a piece of property. They form an LLC. The LLC is there so that they get protection. The property is owned by the LLC, and the members invest in the LLC and run it. It could be one member, it could be two members. That's how it usually starts, and that's a really good idea. If you're in the business of commercial real estate, you'll find that almost every property is owned in some entity, and many of them are owned just like this in LLCs. Now, when you get more than one or two investors, someone needs to take charge. And here's a picture of what my business is. I help people write the legal documents so that they can get a number of members to invest in the investment LLC, to own the property. That's where the borrowing will go, in investment LLC. But we're going to form a manager LLC. The manager needs to be protected with an LLC protection for lawsuits from other investors. So the manager, 2 or more people, takes care of managing investment LLC. And when the manager goes to get the loan, the lender underwrites the manager. And sometimes the lender wants more net worth or more liquidity, and you might end up having an enhancer. And I'll be back to that picture in just a second. But this is generally how we do our business. So securities laws. Securities laws were started because the government said we need to protect those members who are investing in situations where there's a manager running the enterprise. We need to protect them, and we need to protect them in a couple ways. First of all, those members should get complete disclosure, full disclosure, typically writing the documents, a private placement memorandum, an operating agreement, giving the members full disclosure before they invest. And the rule is all the material facts before you invest so that the investor can make an informed decision. That's full disclosure. That's the basis of the first security law. The second security law that came out about the same time was to license people who sell securities of someone else. And so there's the whole gamut of what type of a securities license can you get. You get educated, you take tests, you get fingerprinted, there's a background check, and you can sell securities of others. Now, we don't have to worry too much about that in my business, because just like real estate, where there's a for sale by owner exemption from having a real estate license, there's a for sale by owner exemption in the securities world. It's called the issuer exemption. If you issue your own securities, you can sell them without a securities license. But if you're not the issuer, you can't sell those securities unless you have a securities license. So the rules want to make sure the investor gets all the information and that the people who are selling the securities are actually the issuers of the securities. Now, in the definition of security, in the 1933 rule, there was a word or a couple of words called investment contract. And this is how we work today. An investment contract, there was a case that got to the Supreme Court, and the Supreme Court said, well, we're going to define investment contract. And we defined investment contract by an investment of money in a common enterprise with an expectation of profit. And the profits are generated through the results of someone else. So if all 4 of those prongs are present, it is a security, and welcome to the securities world. So let's go back to my picture. We said that the investment contract is an investment of money in a common enterprise with the expectation of profit through the results of someone else. So if there's a manager in investment LLC, it is a manager-managed LLC, and that by definition is a security. So now you have to raise money and you have to do all this in the realm of the securities laws, or you're in trouble. Because when they passed the securities law, they said every security that's being sold has to be registered with the SEC unless it's exempt. Well, we want to do exempt offerings, and that's what Regulation D is an exempt offering. So we want to follow the rules. People are raising $2 trillion last year following the rules, so you can do that too. So this kind of a flow chart we have at the top. The real question is what you're intending to do a security. Well, how do you know if it's a security? Well, generally, if it's manager managed, it's a security. The first picture I showed you didn't have a manager. The members made all the decisions themselves. Everyone voted equally. No one had a bigger vote than anyone else. And you could call that a member managed security, but that's hard to do with a lot of people. So you're going to have a manager managed security, a manager managed LLC. You're welcome to the security world. And there's a whole bunch of ways you can work, but how you want to work is you want to work where offerings are exempt from SEC regulation. If you go over into the black square, you have to deal with the SEC. So you want to stay in the red square, offerings exempt from SEC registration, and $2 trillion is raised in Regulation D. That's where you want to work. Regulation D now has two parts to it. When I was a syndicator, Regulation D, there was just one part, and it was called Rule 506. And it's on the left-hand side of your screen. 506 said I could raise as much money as I wanted. I could get my money from as many accredited investors as possible. The investors, because I knew them, if they said they were accredited, they could just check a box and that would be fine. And I could get 35 sophisticated investors to deal with me. Now, there's another video on our YouTube channel called 3 Words. And in the 3 Words video, it talks about sophisticated, pre-existing, and substantive. Well, I've just talked about sophisticated. That's a classification of investors that lets you know that they know what they're doing and they can read the documents and maybe make a decision for themselves. But on the bottom it says, no advertising or soliciting. Generally what that means is you had to have a pre-existing relationship with an individual before you brought your offering out, and it had to be substantive. You needed to know if they're accredited, if they're sophisticated, what's their educational background, can they understand what you're going to talk to them about. So it's not just a name you put in your database. That's not it. That may very well prove pre-existing because you put the name in the database before your offering came out, but it has to be a substantive relation. And that has to be with the accredited investors and the sophisticated investors. What we're trying to get at, or what the SEC is trying to get at, is the general rule that there can be no sale, no offer of a current or contemplated securities offering through solicitation or advertising. So you have to know the people ahead of time. And what did we see earlier? We said that of the $2 trillion, $1.9 trillion today is raised in 506B. So everyone wants to know the rules and follow the rules. Now, there was a couple $100 billion raised in 506C. 506C came to us new in 2012 through the Jobs Act. And basically, it's the same as 506B with one exception. You can advertise. You don't need a pre-existing relation. You don't need a substantive relation. You can put it out on Facebook, and if someone will send you a check, that's just fine. But because you're advertising, that changes another couple things. Number one, you don't know who's investing. So there are rules, and I talk about it in my book, on how you verify that the investor is accredited. The rule is that you as the sponsor have to take reasonable steps to assure that the investor is accredited. So it's like a third-party check. So we have to make sure that the investor is accredited. And number two, because we're advertising, there can be no sophisticated investors. So everyone has to be accredited. So that's where the $2 billion is raised. $1.9 billion in 506B, about $200 billion in 506C. And when you call your attorney and you talk about, with our firm, it's called a deal structure interview. We talk about how you're going to do your offering. We would walk through all this with you, and we would come up with which way we would recommend you to go forward in your Regulation D offering, so that you do it right, so that you're exempt from full registration at the SEC, and you can get this on the road maybe in 3 or 4 weeks and start raising money. Now, I said there are 3 words: sophisticated, pre-existing, and substantive, and I'm repeating that. Those are crucial if you're going to do a 506B offering, but I'm not going to take the time in this video. You stay right there on YouTube and find the video that's called 3 words, and I give you the definition, and we clear that up. What do syndicators say? People always ask me, well, why is there problems with doing this? Well, one of the problems is you get enough investors, and as I found, the care and maintenance of those partners is overwhelming. At one time, we had 850 investors, and we sent out over 1,600 K1s every year. That was a lot of work, and it was enough to make me think about going to law school and doing something different. And then I do know that the risk is greater than I ever expected. But I'll tell you that the risk generally comes from the people, not the property. Sure, properties go bad, economies change and all that, but if you get 20 or 30 investors in an investment for 6 or 7 years, someone is bound to have some life situation where they need their money back or they have to come to you and talk to you about it. So you have to be ready for that. And a good attorney will have your documents all ready for that because they'll talk about liquidity and continuity. How do you deal with that in your offering? And you'll be all ready for that risk, but just remember, it'll be there. Here's some big mistakes that I see investors making or syndicators. Not having enough time to raise money. Probably you should have 90 days from the time you sign your purchase and sale agreement until you close the property. You can't take money until investment LLC is open and you have a bank account, because if you take money from investors, it goes into the company account. Anything else is commingling, and that's wrong. I guess I really didn't tell you that the securities laws, the 33 Act that we work under, is a criminal statute. So, we have to do it right. Paying finder's fees, I did say that if you're selling your own security, you don't need a securities license. But if someone else comes up to you and says, hey, I want to sell your security, you cannot pay them for that. They're going to want to get paid unless they're a securities agent. If they have a securities license, they'll ask you to sign a selling agreement with their company and you can go forward and pay them, but not unless they're licensed. The biggest mistakes in all this is thinking you can draft your own documents. These are legal documents. People sign them. There are responsibilities, there are remedies. It's a legal document. If you're doing that and you're not an attorney, first thing, it's the unauthorized practice of law. Second thing, if your deal goes bad, you're going to go to court, and the attorney on the other side is going to say, Mr. Trowbridge, aren't you aware that it's common practice in the industry that an attorney drafts the legal documents, but in your case, you drafted them yourself, didn't you, Mr. Trowbridge? Yes or no answer? You're in real trouble if you have to say, yes, I did. Not reading and following your documents. Just because someone like me writes the documents and gives them to you doesn't mean you can run off and do business. You have to read them and understand what the documents say, because I'll tell you, some investors will, and then they'll ask you about parts of the document. And if you don't know how to answer it, or you say, I haven't read that, you'll lose that investor. Making cash distributions from reserves. You promise to make some sort of a distribution every quarter. The property doesn't quite make enough money that quarter to make that distribution. I'm going to correct myself. You don't promise. You project. You never promise. You project to make a distribution every quarter. At the end of the quarter, you don't have enough money to do it. So you reach into your reserve account. You know that you're going to have to replace all the air conditioner units in the building. But for right now, you just need an extra $20,000 to make your distribution. So you grab $20,000 from your reserve account and send it to the investors. First of all, what you've done is illegal. It's fraud because you've taken their own money and given it back to them and told them that here's a return on your investment. No, that's a return of your investment. And secondly, practically speaking, you'll never get that money back in your reserve account. So when it's time to do the air conditioners, you won't have enough money. You'll have to go to the investors and say, hey, I don't have enough money to do it. They're going to say, why? You're going to say, well, I used my money to make distributions to you. And the investors would rather have you fix the air conditioning units because that's going to make a difference in the value of the building more than get that small check. Most investors can buy their own groceries every quarter. They don't need the cash flow. If it isn't there, don't do something silly. Cashing out investors with money from new investors, that's what Madoff did. He took in new investors and gave the money to old investors as opposed to investing it where it belongs. And remember, these rules are criminal, so he went to jail. So I told you earlier that I had a book. This is the 4th edition of my book, all about securities laws, and it's written for normal people, not written for attorneys. It started out being written for real estate people. It's expanded a little bit since then, but you can get a free PDF of the book by scanning the QR code. It'll ask you for your email, and you'll immediately get the free PDF. And then it will ask you if you'd like a hard copy of the book. And if you'd like a hard copy of the book, it'll ask you to pay postage. I think it's $9 and $9.95. So that's our gift to you. And one other thing I do want to tell you, you can't do that on our website, but I do have an Audible version of the book. If you go to Amazon and go look under It's a Whole New Business or Gene Trowbridge, you'll get a chance to buy the Audible version of the book. Was pretty good. When I talked about the book, I got to a certain section and I'd say, gee, I want to expand on this from what the printed page is. So it's not just like me reading the book to you. It's a little more interesting than that, and I hope you find it that way. So that's my 2022 primer on the securities laws. What did we do? We talked about how big the marketplace is. We talked about how you get into a security situation when you have a lot of investors, but you need someone to manage those investors. And the securities laws are designed to protect the investors when that happens, when investors invest their money in a common enterprise with the expectation of profit, and it's run by someone else, you are in the securities world. We talked about Regulation D. We talked about Rule 506B, where most of the money is raised, where generally you will start your syndication career. We talked about 506C if you want to go ahead and advertise, but I'd suggest you have a track record before you do it. We talk about some of the common mistakes that I see people make. I introduced you to my book, and now we're at the end. And be sure before you leave, you subscribe to this YouTube channel. Somewhere in the YouTube channel, we have 37 interviews of clients of mine. And I'm always asking them, how did you get started? What do you see for the next 3 years? And what advice do you have for rookies? And they always say the same thing. Don't try to do this yourself. Get someone else to do this with and make it a team, because it's a lot of work, but it's very, very rewarding. So this is Gene Trowbridge with the Trowbridge Law Group saying, I'll see you next time on this YouTube channel.